All right. The court will call the case of the state of Michigan versus Eric Martin, case number 23S00425.
Rachel McDuffie for the people.
And standby counsel, Assistant Public Defender Jay Bellinger for Mr. Eric Martin, who appears via Zoom. Mr. Martin, can you please unmute and state your name for the record?
I'm a living man, capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N family. One of the people, sovereign, not a legal fiction corporate entity defendant with a name similar to mine. And here by special appearance to threaten duress, not willingly. Now, again, I object again to any attorney being appointed to me, representing me. But that's something I want to ask you, Washington. Now, you said you're appointing this public defender. Are you appointing it for me or are you appointing it for you? Or is it
So
just
I
standby?
made my decision on that. It's standby counsel. If you have motions to make, you need to make those at this time.
Yeah, that's how I need. I'm seeking clarification. Are you appointing him against my will to have an attorney appointed for me?
Yes, it's not representing you. He's standby counsel. Please make your motions.
Okay, that's it. Well, that's how I was going to make the motion to dismiss him if you're trying to appoint him for me, which, as I already said before, I will not be taking no attorneys. I'm one of the people. I'm not a defendant who's, yeah. So as I said before, so I'm not going to be accepting any attorneys, and which would then fraudulently give the presumption I'm under the jurisdiction of the court, which I'm not. As I said before,
So you got 5 minutes to make your arguments, and you can spend them however you want to.
All right, yeah. Like I said before, I'm a living man. So as the U.S. Supreme Court said in the cases I cited to you before, there's no jurisdiction over a living man. Corporations don't have jurisdiction over a living man without our consent. I don't consent. And it's also under, there's no consent under the Declaration of Independence of 1776. There's no jurisdiction over a human without their consent. So I never consented to jurisdiction, and I don't now, and I never will. Now I have some...
From the very first second, you can tell this isn't going to be your ordinary hearing. Today we're stepping into the Michigan courtroom where one man, Eric Martin, has decided that centuries of legal precedent don't apply to him. Claiming to be a living man, and not a corporate fiction, he's armed with pseudo-legal jargon straight out of the Sovereign Citizen Handbook. The judge, calm but firm, is about to go toe-to-toe with a man convinced he's uncovered a secret loophole that no one else in history has noticed. But as we'll soon see, those so-called laws crumble fast when faced with an actual courtroom. Stick around, because by the end, you'll see how quickly logic, law, and patience collide in what might be one of the most fascinating courtroom breakdowns.
That's the case anyway, right?
I'm sorry, what?
You said you're going to be addressing some demands for dismissal I already sent to you already.
So first of all, a demand is not a proper format before a court and could be dismissed outright. However, I'm going to allow you to make your motions here. If you want to make an argument, you can do that, sir.
Okay, I object to that. That's not true. As I mentioned before, demands, when someone has the right to something, that's what the terminology demand is made. And that's the only reason why I make it. Motions, even though I know that's all you see in the court rules or whatever, traditional. But that's for a request, and persons are not, or humans are not supposed to be requesting constitutional rights. You know, me exercising my unalienable right, human rights and constitutional rights, I'm supposed to be making demands. That's how I've been, and that's backed up by law. And that's how I've been taught. And so that's what, so it's all right and proper. Motions are requests, and the defendant makes motions also, since I'm just.
So you're about to end of your 5 minutes.
Well, I objected 5 minutes being any time limit also.
I don't care about what you're objecting to. You can make it on the record. It is noted. Now, if you have something that you want me to address, you should do that before your time is up.
Putting a limit on my First Amendment right, that's unconstitutional.
Sir, please, if you want to have something to say other than the circular talk that you're doing, you should probably do that at this time.
I didn't finish. That's why I didn't mean to. No, non-circular. I didn't finish the first time. All right, well, that's it. As to that,
Is the court ready for the people's response run?
I don't know if he's done with his motion.
Oh, I'm sorry.
So I'm trying to make,
well, the police, I want to question the police officer who wrote the ticket. I have a relevant question to him as to self-incrimination, move to dismiss the case based on that. But my memory was it's a little, I don't really remember exactly what was said. That's why I kind of need to question him to refresh the memory. But I do remember in general, though, he kind of, I'm required to give my ID if I remember right, and I might have been arrested if I didn't give my ID, which was under threatened arrest. And even if he didn't say that, which I don't remember, which, like I said, I need to have his body cam and all that. I want that. I want to be able to review that now, and also for the trial, if this goes to trial, I want the video present as part of my due process right for the evidence, which is my due process right, like I'm saying. And because, like I said, it violates my self-incrimination right, that I'm being made to give my supposed name, government name, anyways, which ain't really my name, but a government name has been given. Violates self-incrimination, and then it's used against me to prosecute. So it violates self-incrimination. Yeah. Move to dismiss based on that too. And like I said, if you need more evidence as to, like I said, his questions, then he needs to answer my question. I was about to send out interrogatories to him. I'm about to do it here soon. If you find that's necessary, unless you find it ain't necessary, I'm gonna send it out soon. So
Right off the bat, Eric tries to separate himself from the word defendant, as if changing titles could somehow change the law. This is one of the most common sovereign citizen tactics. They think by redefining legal terminology they can escape jurisdiction. But here's the thing, the court's authority doesn't come from wordplay, it comes from law. And when the judge clarifies that the public defender is only standby counsel, not representation, it's a clear attempt to keep order in the chaos Eric's about to unleash. The courtroom is still calm, for now.
I didn't mention that, but I thought you might kind of already figure that. But conflict of interest due to the lawsuit being filed, that's the grounds of my demand for dismissal.
okay.
And I would like to, Ms. Duffy, as the prosecutor, I'd like to notify you, of the crimes being committed against me by the police officer, in this case, writing the tickets, and I request you prosecute them for this, because I'm the crime victim here in reality. Because I was traveling by right, which the U.S. Supreme Court said we have, as long as you're not carrying passengers property for profit, you're not technically driving a motor vehicle. Therefore, all these charges are baseless. There's no case here. So in reality, I was harassed, retaliated against for exercising my right to travel on my motorcycle, and then with these charges. Okay, so because they had no evidence that I was carrying passenger property for profit, which is what's required. That's the definition of a motor vehicle under 18 USC section 31 subsection 6 and 10. That's when a motor vehicle is a motor vehicle. In contrast to the state law, I know what the state law says. The state law just says, if something's mechanically drawn, it's a motor vehicle. Well, the state statute is in violation of this federal statute. Therefore, it's unconstitutional. Okay, and therefore, the federal statute definition of motor vehicle applies here. It overrides the state statute under Article 6 of the U.S. Constitution. Laws of the United States is supreme over state law. So therefore, I wasn't doing anything wrong. I was traveling by right on my motorcycle, as I have a right to do, without a license, and the U.S. Supreme Court case law that I cited already in the court that they sent back. But one of the main cases here is Packard versus Banton, U.S. Supreme Court case law. Okay, this is a little more specific than just saying people have a right to travel. It mentions there specifically, and I'm gonna mention right here, volume 44, Supreme Court Reporter, page 259. The streets belong to the public and are primarily for the use of the public in the ordinary way. Their use for the purposes of gain is special and extraordinary and generally at least may be prohibited or conditioned as the legislator deems proper. So as they're saying right there, so we do not need a license if we're not using the streets for profit, for gain. I wasn't doing that. The police don't have no evidence of that. So he shouldn't even pulled me over, stopped and wrote a ticket, none of that. So I'm the crime victim. I request you prosecute him for that. And it's also a federal crime, which I'm gonna be contacting the FBI about. I already tried once.
The judge just drew the first real boundary, and this is where most sovereign citizens start to spiral. When told he can't interrogate the prosecutor, Eric objects, claiming it's a violation of due process. But here's the twist. Due process doesn't mean you get to run the courtroom like a talk show. It means you're given a fair chance to present your case within the rules, the very rules he keeps rejecting. Notice the pattern. He demands rights but refuses responsibility. That contradiction becomes the centerpiece of every sovereign meltdown.
Because that's one of the fraudulent things going on in the court system. I'm gonna be filing a class action to stop this on a grand scale, but I know it's happening. That's why, like, for example, I use the word demand, so you use the word motion, and it can be presumed you're a defendant. Because defendants make motions, see? So that's why there should be no legalese used here. It's fraudulent, it's wrong, it's immoral, it's pathetic. Whoever made this stuff, you know? Because it's putting it's a blanket on a lot of people. They don't know no better in the system. Something else. Now, when this proceeding started, I noticed on the screen, it said no recordings are allowed. Okay, now I object to that, in that violates my due process right to preserve evidence, me or anyone else, and I'm not just speaking for me, I speak for everyone else. All the people have a right to record in any public court. This is all public. U.S. Supreme Court already said this. People have the First Amendment right to record in public anywhere. And it's also a due process right to preserve evidence. Because if my rights are violated during these proceedings or any other, along with anyone else's, we have the right to record that and have that evidence to bring criminal or civil charges. So that's why that's not supposed to be popping up on the screen, that video, audio.
Thank you, Your Honor. So I am aware of 5 items that have been filed by Mr. Martin, I think after this case began to be pending in this court. And I'll just briefly address as to the formatting of those. I did notice all of them are handwritten. He does write a date on the top of each document, but then he usually signs off with a different date on the bottom of the document. So if it ever comes into play that there's an issue with the timing with respect to deadlines or anything like that, for my purposes, I'm just going by the date that it was received by the court, which is usually a third date that is different from the other 2. So the first document I'm aware of is titled Demand for the Return of My Motorcycle. That one was received by the court July 27th, or yes, I believe somewhere around there. I'm sorry, I'm not going to the dates aren't really important, so I'm not going to dwell on those. I'm just addressing these versus actually, I think, responding to them in detail. Defendants specifically ordered and demanded that the troopers from Michigan State Police return his motorcycle in this case. That is a request to police that was filed with the court. No response appears to be required or called for from the people, so I don't have anything to say about that. Next is the motion that was filed for the disqualification of the judge in this case. And I just wanted to point out a couple of things. First and foremost, as Mr. Martin pointed out, the court rule that relates to disqualification of judges, MCR 2.003, speaks to the exact procedure for that. In a single judge court, and actually the challenge judge here is the chief judge, the challenge judge is the person who decides this motion. So I don't have any argument to make as far as that, but I would point out there is a quote included in that particular motion that challenges this court's jurisdiction. And it cites a case from, what's that? Oh, yes, Penhallow versus Jones Administrators. That's a case from 1795. And the specific quote that was cited in that case to challenge this court's jurisdiction, it's a paragraph or so. It begins with something about, heavens, let me see. I want to make sure I have it correctly. I don't want to, it's not really important. In as much as every government is an artificial person, a creature of the mind only, all that stuff about artificial persons. I think Mr. Martin already made some references to that. I just want to make sure that Mr. Martin is aware That specific quote does not exist in that.
Here we go again. Eric insists on using the word demand instead of motion, claiming that requests are for persons, and he's a man. This linguistic gymnastics is how sovereign citizens convince themselves they've found a legal cheat code. But the judge's patience here is incredible. She allows him to speak, even though she could have dismissed this line of argument outright. It's a great example of judicial restraint, letting someone talk themselves in circles until the absurdity becomes undeniable. If you listen closely, you can hear her professionalism holding back a sigh.
Regarding the power he believes is lacking here due to municipal court status. But FYI, the Michigan District Court Act of 1968 did abolish most of the municipal courts. 4 of them are left that they did allow to remain: Grosse Pointe Farms, Grosse Pointe Park, and Grosse Pointe Woods. All of those are in Wayne County. We're in Washington. So just so that Mr. Martin is aware, this is not a municipal court. It's a district court. Finally, as to the motion to disqualify, as I mentioned, that is for the judge to decide. But I might want to point out the manner in which he chooses to pursue that disqualification, including any comments or insults. For example, on page 9 of his motion, when he says that also Washington is not a real judge, but a clerk masquerading as a judge. Pursuing disqualification or recusal, or even a federal lawsuit, does not insulate you from the contempt powers of that very same court, should you choose to continue escalating that type of behavior. That's just the more you know from me. Third, next document that was filed from this court, it's titled Martin versus Mike. Plaintiff's response and response and objections to my return criminal complaint on Mike and the attached court letter that vaguely, unfairly stated filings does not comply with MCR 6.101 and 6.102. I didn't have a letter attached to that to refer to, but it looks like that is the court's rejection of an improper filing or format. I honestly have no idea who Mike is, but the people of the state of Michigan are not listed as a party in that filing, so I don't really have any response to that either. I can advise, though, that Mr. Martin mentioned earlier, and it's stated here, that the reference to this criminal complaint, because a defendant refers to himself as a plaintiff and titles something as a criminal complaint, it doesn't make either of those things true. So I'll direct Mr. Martin to the same court rule he actually cited in that filing, which is MCR 6.101. The prosecutor's approval or posting of security. A complaint may not be filed without a prosecutor's written approval endorsed on the complaint or attached to it, or unless security for cost is filed with the court. I just wanted to disabuse him of that notion that because he creates a criminal case, I guess in his mind and on paper, it doesn't mean that. So nothing more from that. The court's rejection of an improper filing really isn't my business. So no response from opposing counsel would apply to that. The last 2 things that were filed before the court are 2 demands. The court has already mentioned demands. I'm so sorry. It's a lot of talking happening here. I gotta refresh. 2 demands. 1 demand for default judgment and another demand for summary judgment. Both of these, I would have the same reaction to. The demand for summary judgment, summary disposition concerns parties to a civil action, and defendant is referring to civil procedure, not criminal procedure. There is no summary anything of that notion in criminal matters. Now, he made some references to Article 3 of the US Constitution. That pertains to federal courts, appointment, tenure, Supreme Court justices, federal circuit and district judges. Those are Article 3 judges. Those are the ones nominated by the president, confirmed by the US Senate. So this court is not controlled by Article 3 of the US Constitution. But I think he knows that because he's citing Michigan court rules to sustain his argument for pretty much everything else. So that doesn't change here. Summary judgment is not a thing here. Default judgment. Now, that's not quite the way it works. I think he argued that because the prosecutor in court did not respond to the request to return his motorcycle.
Now we reach the self-incrimination argument, another sovereign favorite. Eric claims giving his ID violates the Fifth Amendment, as if identifying yourself is the same as confessing to a crime. In reality, the law requires you to identify yourself during a lawful stop. That's not self-incrimination, that's compliance. His logic, however, runs deeper into fantasy. He wants to subpoena body cam footage, file interrogatories, and even threatens to send questions to the officer. At this point, he's treating a simple traffic ticket like a Supreme Court trial. The judge, though, keeps calm, methodically bringing him back to legal reality. And there it is, The ultimate sovereign citizen move, suing the judge. When logic fails, they pivot to threats of legal retaliation. Filing or threatening a lawsuit against the presiding judge is a tactic meant to force recusal, but it never works. Courts see right through it. In this case, the judge denies his motion to recuse without hesitation, knowing it's nothing but a stall tactic. The irony? Filing a frivolous lawsuit like that can actually hurt his own case. Still, Eric doubles down, convinced he's exposing corruption rather than demonstrating delusion.
Well, I think that she said so much. I took some notes, but I couldn't take notes on everything. Hard to follow along with everything else. I think it's best to, same with me too. I say one thing, allow her to respond back. She says one thing, then allow me to respond at one set of, you know what I mean? Like me saying a whole bunch, and then her saying a whole bunch, because it's hard to follow along for both of us. I think harder, at least me, and for both. I think it's common sense. But all right, well, so I'm gonna respond now to the things I could follow along with, and I took some notes. But I'm gonna need her to say again what I missed, and then I can respond one by one. Okay.
It's not how this is gonna work, sir.
That's
I
not
think
how
to understand here, you
I have the right to that. What are you talking
you're not controlling this courtroom, sir. That's not how this works.
I'm speaking about what I have a right to do. I have a right to respond back. So
You're
All
gonna
right.
get 5 minutes and I'm gonna be done. So that is your opportunity. And after that, I'm gonna make my rulings. You got
So-
5 minutes. I'm actually setting a timer.
All right. Again, I object to that again as being violates my due process right to the First Amendment. It's not supposed to be regulated by a certain time limit. My First Amendment right to say what I got to say, based on an arbitrary, unfair time limit.
Sir, in a minute, you're pushing towards being in contempt of court. You got 5 minutes. You can make your objection, which you've done. You got 5 minutes. Now please move forward.
Criminal. Yeah, I want to object to that too, though, about what you said about contempt of court. Exercising the First Amendment is not contempt of court. It's nowhere close to that.
There's no First Amendment right in this courtroom, so you're a defendant. You need to actually do what is requested of you, and I'm giving you an opportunity to make your argument.
As to the criminal complaints, in response to what you said about that MCR, the refusal to act on my criminal complaints that I filed because of MCR 6.101. And now, first of all, it violated my due process right, obviously, because they didn't mention a subsection of that rule. There's many subsections. Okay. So I'm still left in the dark and what specific subsection it is. And all those apply to specific fact situations. So that was the first due process violation right there, just mentioning that too vaguely general. Number two, but assuming it was based on not paying a fee or whatever, I think like she mentioned, or getting a prosecutor's approval. Okay, if it is for that reason, those reasons are unconstitutional and therefore it's invalid. That court rule. That's why I'm going to file a class action actually on the court rule. And I'm going to get that court rule and get up out of there because it's not legit. Why it's not legit?
The right to travel argument, the crown jewel of sovereign mythology. Eric insists that because he wasn't carrying passengers for profit, traffic laws don't apply to him. He even cites federal statutes and misreads Supreme Court opinions, blending real law with pure fiction. But here's the truth. Courts have ruled countless times that states can regulate the operation of vehicles on public roads, profit or not. His insistence that he's a traveler, not a driver, is like arguing gravity doesn't apply because you call it earth attraction. The prosecutor hasn't even spoken yet, but you can already tell how this is going to. By now, the courtroom has gone full circle. Eric's still arguing semantics, the judge remains composed, and the prosecutor is ready to dismantle what's left. What we've seen today is a masterclass in patience and procedure. Despite endless objections, pseudo-legal theories, and even a surprise lawsuit, the judge never lost control. Cases like this remind us why courtroom order matters, not just for justice but for sanity. If you found this sovereign citizen breakdown as fascinating as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom moments where logic meets law, and law always wins.